A very good evening to you and welcome to Big Talk here on Global Television, coming to you live from the nation's capital, Abuja. My name is Godwin Sunday. All right, it's a good time for you to call your friends, call your family members, and also your relative. Let's delve into big conversation because today the conversation is really going to be big. And of course, you can join us on our social media handle right now, showing on your screen using at Global TV NG. And you can also download the Global TV Nigerian mobile app from your Android and iOS devices to also keep track of our broadcast. Now let's delve into the conversation. Today we'll be assessing President Bola Ahmed Tinubu's administration, but we're taking it from the angle of the judiciary. How far has the president come, even with obeying the court verdict, the judgment of the court, from the lower court through to the higher court? Looking at it from the various tiers of government, the local government, the state government, and also the federal government against itself. We'll look at all of this and try to marry this through with some of the issues that we have across the country, not forgetting the fact that also in Mokwa local government area of Niger State, it's been bedeviled by a flood, and right now, by the figures right now, more than 200 people have lost their lives, and also more than 500 people are still missing. Our heart still goes out again to the families that have lost their life. Now let's delve into the first conversation for tonight, which centers on the judiciary in focus. Joining me in this conversation is Barrister Balogun Akintayo, and he's a legal practitioner. We'll be talking this evening from the legal angle. You're welcome to Big Talk, Barrister Akintayo Balogun.
Good evening, and thank you for having me on the show this evening.
All right, Barrister, let's begin the conversation by first looking at President Bola Ahmed Tinubu's administration for the last 2 years. What do you make of the various court verdicts and the implementation and also obeying the court processes so far?
Okay, looking at the last 2 years, to a large extent, I tried to do an extra of a couple of judgments that were delivered during this period. And to a large extent, I would say that the federal government have complied to a large extent. Now, if you look at it in the last 2 years, we've not really had so many judgments that directly affects the federal government or that gives an order to the federal government either to restrain them or to tell them to carry out an action. Basically, I think one major judgment that was delivered during this period was the issue of the autonomy of local governments at the Supreme Court, and we saw the immediate implementation of that judgment of the Supreme Court. Immediately, the 36 states, the local governments in 36 states, elections were conducted all over the federation. So basically, to a large extent, I think we have seen compliance with judgment of court. And, if you also look at it to an extent too, most of the decisions to a large extent have not been against the federal government. So, once decisions are not against you, there might not be anything so much for you to say you have to act against. If judgment is in your favor, is to just keep quiet and clap your hands. But then you realize that most of the judgments, there has actually not been any as such that you will say this is against the government needs to act otherwise. But at least for the ones we have seen, like the issue of the local government, immediately elections were conducted within the period that the Supreme Court ordered that elections be conducted. So I think to an extent, the federal government have been compliant.
All right, the federal government have been compliant. Let's talk in terms of the various courts that have sat down, from Justice Nyako in the case of Nnamdi Kalu's incident. Let's look at that and trying to assess the government's state of compliance even around that area. what's the level of compliance so far? Because before Justice Nyako backed out of that case, it has been a talk of war for the federal government to implement that certain court judgment.
Okay, let's not just talk in abstract, but let's look at the issues as they are. Now, the Nnamdi Kanu is before the court. Ordinarily, the presidency should have no influence whatsoever in whatever happens in court. Now, there have been several calls, both by leaders from across the nation, some governors, and they've called for his release. Now, talking about his release will now be at the discretion of the government. The government can say, okay, the Attorney General can decide to enter, we call it a nollie prosecute, and say, okay, they are taking over the prosecution. They have not seen any reason why this prosecution should continue, and then can now withdraw the matter. That is the extent to which the federal government can be involved. For example, we saw that something like this happened during this case involving this Yoruba agitator. Can't remember his name now. You know, the federal government entered into, and that matter was withdrawn. We've not been hearing about it again. The same thing too applied to Sowore. You know, the AJ also entered into it, and that matter ended. But you know, that of Nnamdi Kanu, of course, probably for some security reasons or for reasons that the federal government would not want to specifically disclose, it has still allowed the court to still have its way in this one. So if you look at it, in the case of Nnamdi Kanu, the court is not directly involved. We can't say the court, the federal government is not directly involved. We can't say this is what the federal government is saying. It's like the federal government is just allowing the court to have its way. So everything that has been playing out now is between Nnamdi Kanu, his lawyers, and the court. When Justice Nyako had some when he confronted the judge, she removed her hand, she recused herself from the matter. But then the chief justice, the chief judge of the Federal High Court, still pushed the matter back to her. And then she still looked at it again and said, no, let this matter go back to the CJ. And then the CJ now, in his wisdom, now said, okay, since it is like this, he now assigned the matter to a different judge entirely. Now, since the matter came before the new judge, you know, there were some rules, some guidelines that he put down. This is how this matter should be. This is how, and you know, since then now, there have been a lot of progress. They have called quite a number, not less than 3 witnesses have been called, you know, since then. So for me, or let me say, physically or from what we can see, there is no hand of the federal government, that is the presidency, in what is going on. All we see is someone that has been charged to court. There are charges that have been made against him, and he is being prosecuted in line with those charges. Now, remember that the initial charge that was brought against him, the federal government, not the federal government now, his lawyers made an application to the court and said some of these charges cannot stand. Justice Nyako delivered her judgment and said yes, some of these charges cannot stand, and removed them or struck them out. Now, they went on appeal to the Court of Appeal and said the remaining 2 should go. Court of Appeal said no. They went to Supreme Court. Supreme Court said no. Let this matter go back to the Federal High Court and let it be prosecuted. So, if you look at it, you realize that the judiciary is just allowed to have its course. If the federal government wants to intervene, all we will hear is AG has entered in, taken over the matter, and is probably withdrawing, or he wants to prosecute it by himself. So for me, openly, as much as the eyes can see, there is no hand of the presidency in the matter.
All right. There is no hand of the presidency in the matter. Let's bring it back to the issues around the Labour Party and other political parties. For the first time in our nascent democracy, we're seeing the Supreme Court coming out to say that let the various aggrieved party members, let them go and resolve their issues, and thereby throwing more political parties into a state of comatose. In this stance where the Supreme Court even did not even listen or adhere to the prayers made to the Supreme Court. Rather, it stood on a position and took a stand under President Bola Ahmed Tinubu. A lot of people will say that the judiciary, even from the Supreme Court in that regard, was answerable to the president. But when you begin to assess the president in this particular administration in this light, can we say that the president largely is in control of the Supreme Court?
Well, I wouldn't want to say the president is in control of the Supreme Court. That would be a very dangerous remark that could have some dangerous effects. So that would be a very dangerous conclusion to make. And but then the truth is that there have not been total consistencies in the decisions of the Supreme Court, particularly on issues involving political parties. Now, let me give an example. Sometime in 2017, 2018, that period, there was serious battle over the leadership of this same People's Democratic Party. That year, 2 persons were claiming ownership to the seat of national chairman. Former governor of Kaduna State, Senator Makarfi, and former governor of Borno State, person that handed over to Shettima, I'm trying to remember his name now. You know, those 2 persons dragged issues of leadership of PDP from the Federal High Court to the Court of Appeal to the Supreme Court. Now I remember vividly, Supreme Court took a position. And the responsibility, or let me say the Supreme Court recognized the caretaker committee led by Senator Ahmed Makarfi. You know, and with that decision of the Supreme Court, it laid the entire issue of leadership of the party to rest. That was the end of the other person, I can't remember his name now. That was the end of his claim to the chairmanship of the party, and before you know what, he went back to APC. So Makarfi now came in fully as the leader of the party, though in caretaker capacity. I think the person that took over from him, I think should be Secondus also. You understand? So it was a decision of the Supreme Court. At that point, Supreme Court never said anything like it's an internal affairs and all that. Now, fast forward to 2025. An issue like that gets to the Supreme Court. Labour Party gets that kind of issue to the Supreme Court. PDP also comes to the Supreme Court with that kind of issue, though their own now has to do with Secretary General. And then the same Supreme Court now, looking at the same issue, Supreme Court says, no, these are internal political affairs, or these are internal affairs of a political party. We cannot be involved in the decision making. Now, you see, this like the position has changed. Now, we don't know if tomorrow there would arise another Supreme Court, that would say, no, we have the power to determine who is the representative or who is the chairman of the party. You understand? So that is actually the problem that we have presently. I wouldn't want to say this is the influence of the president or not. For me, I would rather see it as the position that the Supreme Court have decided to take at this time. If tomorrow it changes again, they are the Supreme Court and they remain supreme, and whatever they say is supreme. So, but for now, the position remains that the court will not interfere in matters that involve leadership of a political party.
Well, this is quite interesting, but going with your narrative so far. But let's talk about the issues surrounding political parties and the decision of the Supreme Court, even for Labour Party, for the People's Democratic Party, and by extension, this is binding on several other political parties that are also going through this whole internal conflict and rifts within this party. For Nigerians, they will say that the Supreme Court has made political parties to be more confused and more perplexed in not coming out to categorically state its position on where it stands in resolving their conflict. Since they didn't come, they knowing fully well that they had internal conflict, they prayed to the court to listen to them and take a decision for them, but the court referred them back to their own vomit, as it were. But in this particular case, can we now say that the Supreme Court under President Bola Ahmed Tinubu has been more effective and more efficient in terms of the way it has handled issues so far across the country?
Well, like you know, just last year we had the new Chief Justice of Nigeria was sworn in. So let me say by September now it will become 1 year that she is serving as the substantive CJN. She had acted for some months before is it September or October last year. So within this period, of course, there have been a lot of reforms in the Supreme Court. There have been a lot of changes, and I can say that there have been a lot of improvements. You know, there were so many things that were lying fallow, you know, in the Supreme Court, and within this 1 year, there have been a lot of improvements. There have been a lot of changes. You can see that the current CJN is quite dynamic in her approach on issues. And then you also note that when she also came into office, she also inaugurated the new Supreme Court rules as amended. You know, so a lot of things actually came in as she stepped into office. Now, I wouldn't want to tie it to the presidency. Remember, the presidency, which is the executive, and the judiciary, are meant to be independent. They are supposed to be independent.
Are they really okay? They are supposed to be independent.
Yes,
okay.
Yes, they are supposed to be independent.
Okay.
So I wouldn't want to say that the presidency or the executive now is having any influence or any mandate or any authority over the judiciary. You understand? So let's just see it as everybody doing their work as it is supposed to be. The Supreme Court, under the leadership of the new CJN, in the last 1 year, there have been a lot of revolution. There have been a lot of things that have evolved. And then I just see it as somebody coming into office and say, see, I need to make some things right. I need to right some wrongs. I need to correct some things. There are some files that I know of some applications in the Supreme Court that have been piling up for several months or running into years. And immediately she came into office, I know, I'm talking as in someone who goes there and sees one or two things that should be done. She cleared them off. She let these things, she made things to work. So I wouldn't want, like I said, I wouldn't want to tie this to the executive or to the presidency. Everybody is working as an independent body, as enshrined in the Constitution.
Well, when the new CJ was sworn in, fortunately, unfortunately for Nigerians, we also had the minimum wage that was also implemented, moved from what we were before to 70,000 naira. For most people, most states are even clamoring for more than 70,000 naira. And one of the things that follow is more of the remuneration increment in terms of salaries for judicial service. And people will say that that was an inducement to induce the judiciary in order for them to tilt their sword towards favoring the president. And this is what has played out so far under President Bola Ahmed Tinubu, where if a case that doesn't favor the presidency gets to the court, it will be squashed. But if it favors the president, it will be upheld, even in its generality. But when you begin to assess, as the court become complacent in terms of its judgment so far, based on your own assessment of cases that have been presented to various courts, from the lower court through to the higher court.
Okay, I would want to correct the issue on their remuneration.
All right.
Now, remuneration, remember there was a judgment of the National Industrial Court. You know, the plaintiff in that matter was Leonard Silk, Sebastian Hans, SAN. Yes, he was the one that took that matter to court on the issue of remuneration of judicial officers. You know, and a judgment was delivered, and you know the court delivered the judgment and said this is how the payment should be made. Now, if I recall well, the eventual remuneration or the correction now, I'm not sure it was done during the time of this presidency. I think it was towards the end of the presidency or towards the end of the tenure of President Buhari. I'm not 100% sure now. But I think it was towards the end of his tenure that the issue of salaries, there was now an increment. I think a very huge increment where salaries were moved to some to about 10 million, 12 million. If my memory recalls well, I think that thing happened towards the end of the government of President Buhari. But for the judgment in the matter that was taken by Mr. Sebastian Hans, SAN, that matter was decided while President Buhari was still in office. So I wouldn't want to say that issue of remuneration was something tied to the presidency. No. The whole process the clamor has been on for several years. Several years it's been on. You keep hearing judges saying they've been on the same salary for over 10 years, and all that. You hear that a lot. And then before this present government, the issue came to the fore, and I'm not 100% sure now, I think that decision was made before President Tinubu came into office. So the issue of remuneration, I wouldn't want to tie it to this present government.
All right. So you're saying invariably that all the remuneration increments was not to induce the judiciary into becoming complicit in taking decisions even that will favor the federal government in any capacity.
No, because let's look at it. We heard of judges that are being paid the same salaries for maybe 15 years. That is not, it doesn't sound well. It doesn't sound good. It doesn't sound reasonable. In a good setting, salaries at worst or at worst 3 years, there should be an increment. And not even in a country like Nigeria where inflation is something else. And then you still want to keep people tied on the same salaries for 15 years. I think that was not. So for me, the increment or the change in remuneration was many years overdue. Many years overdue. That was. So even if it happened during President Tinubu's time, I would call it a coincidence of something that should have been done more than 15, 12 years back. It's not something we're supposed to be talking of. These people should have been earning this amount long ago. So even if it happened during his time, I would see it as a coincidence.
All right, a coincidence it is from your own standpoint. But there's one common balance that has even aroused from most Nigerian conversations right now, with it locally and even in what they call local beer parlor conversations, if you permit that. When they say you're pissed over something or you're angry over something, the next thing you hear is go to court, because this was what was used by the Independent Electoral Umpire of Nigeria, Electoral Commission, the person of Mahmoud Yakub. If you're dissatisfied, you can go to court, and all of this. Nigerians will say that because the INEC and the Electoral Umpire can predict the outcome of the decision of the court, that's why they will tell you to go to court. That is, the judiciary is almost losing its value. It is becoming more of a toothless bulldog. Hence, they can tell you go to court because they know that they control the judicial system. But I don't know how correct this narrative is. But as a lawyer, in the light of this go to court conversation, does it imply that the decision of the court as of today under President Bola Ahmed Tinubu can be predicted and the outcome certain?
Okay. Yes, INEC said go to court. The chairman of INEC said go to court. Well, for me, that was actually an unfortunate remark. You see, you have to admit, when something goes wrong, you have to admit it. Now, after telling everybody go to court, spoke to people, it's like you can do your worst. That was more or less what the response was. Now, the same INEC later on came up and said there were glitches. Now, it's like you had boasted that nothing can happen. But then now you have realized that there was a problem. And then you said, you now started saying there were glitches and all that. So for me, that remark was quite unfortunate, and I wished that he withdrew that statement. You know, when this recent incident happened of JAMB, this JAMB
saga,
you know, and the registrar came up and he actually said there were glitches, and he apologized. And you know, you could see that yes, there was an error. You could see it all over the registrar. Yes, there was an error. He admitted, and then corrections were being made. Now, you compare that to what happened in INEC. INEC simply said, go to court. The following day, they said there were glitches. So, the truth is that the issue was not properly handled well by INEC. And now, let's now see, we went to court. How many of the decisions were overturned? Just very, very few. Very, very few. Maybe one I can recall, the case of Natasha. Natasha at the polling unit or at the place where results are being called, you know, she was declared the runner-up. But then she went to court, and good to read, she won at the tribunal, went to the Court of Appeal, and the decision, the judgment of the tribunal was upheld. You know, so that's a typical example of someone who went to court and succeeded. But then there were so many that went. In fact, practically, let's give it 90% went to court and they failed, because it's, you know, they said by the year it's like the courts are making it more difficult. They said it is now easier for a camel to go through the eye of a needle than for a petitioner to successfully prove his petition. That is what the situation has become now. It is very difficult. And the decisions of the court every day is making it more complicated. It's just like this issue of decamping now. You know, the Supreme Court have made it extremely complicated or extremely difficult for you to remove a senator that decamped to another party. So that's just the same thing now that happens. That's why INEC will say, go to court. Because INEC knows that if 10 persons go to court, 9 will most likely fail in court. So that's the unfortunate situation that we have found ourselves, and we are hoping that with the next election year coming close, a lot of corrections will be made, a lot of things will be corrected, so that we can see our elections and be proud of them, and look at it and say, yes, these results are good, and leave it as it is.
All right. Let's talk in terms of the principles of rule of law in the country. And one principle that the rule of law has always championed is a principle of impartiality before the law. But there's something when it has to do with the just concluded 2023 election that brought in President Bola Ahmed Tinubu, and that has become like a recurring phenomenon and a common decimal factor in this administration, where we have a situation where we have a serving senator that was contesting for presidency, and he voluntarily withdrew from the presidential race and still went back to collect his mandate. People said that the election was marred with a lot of irregularities. The person that the representative of the electoral umpire that went to conduct that election right now was tried and was sentenced, but the election was still declared free, fair, and credible. Doesn't this also ridicule the position of the judiciary, even within assessing it even in the light of President Bola Ahmed Tinubu's administration so far? And it's, of course, the AG never came out to speak up on that particular in that particular regards.
Okay, I believe the judgment you are talking about is the one involving the Senate President. I want to believe that's where the professor that conducted the election, that declared the result. Now, I want us to get the information correct.
All right.
That incident was not in relation to the elections of 2023. That's actually the mistake that many people have been. That was in relation to the election of 2019, not this recent election. That was with respect to the election of 2019. So even if the person who conducted the election, is convicted, you cannot, because of that, now go after Akpabio for what happened in 2019. The truth is this: when the professor was being prosecuted, was Akpabio brought in as one of the co-defendants? The answer is no, he wasn't. The entire prosecution, everything was just around that umpire, the person who stood as the umpire. And that was with respect to the election of 2019. So even if you have a window to challenge the election, you cannot be challenging 2019 election in 2025, because the tenure, the period has passed, has elapsed. Now, if this decision had been made, let's say sometime in 2021 or 2022, fine. Probably someone can go to court and say the person who produced Akpabio as the candidate has been found guilty, so this person cannot continue in the seat. That would have been a different matter. But that is not the situation this time around. This 4 years has elapsed. So he cannot be held for what happened where the tenure is over. If Akpabio had been prosecuted together with the professor and said, okay, professor, you are the one that announced the result as influenced by so person, it would have been a different ball game entirely. We'll say, okay, yes. But then everything was done independently. So let's not still point accusing fingers at the judiciary. Remember, judiciary they are not the prosecutors. They are not the ones that will go and hunt for persons that committed an offense. They are not the ones that will go and ask questions. The judge does not ask questions. All the questions are being presented by the lawyer to the prosecution and the lawyer to the defendants. The judge is there to simply receive the things that you have brought in. Whatever you have brought in, that is what they would receive. And it is upon that they would give their verdict. So let's not look at it as the person is still in office and all that. Number one, it happened during the election of 2019, and it cannot affect a tenure that started in 2023. I don't know if you get the
I do.
It cannot affect a tenure that started in 2023.
Okay, but the professor can still suffer for his offenses for 2019.
He has to.
And the law cannot be retrospect.
Well, it cannot. Well, in this sense now, let me not say it cannot have a retrospective effect. Now, what is the retrospective effect that it can have? The only retrospective effect that it can have, if you would ask me, the person who was the runner-up cannot be declared the winner any longer, because that time is over. But we have seen judgments of the Supreme Court that says whatever you earned within that period, salaries, emoluments, allowances, everything that you have earned within that period can be recovered from you. We had that in, I think some few years ago, where somebody was serving as a member of the House of Reps. I can't remember his name. He was a bit controversial during his time. And then while he was, in fact, he was the chairman of one of the committees. While he was serving, his seat was declared, they said it was someone else that won the election. And the court ordered that every money, every salary you have earned within that period should be returned. So that is the only retrospective effect that can happen in this circumstance. No other person can be declared the winner of the seat between 2019 to 2023. The only thing now, and this would only happen if someone brings the matter to court. The court will not on its own say, okay, whoever was declared the winner during the period should... they said the court is not the Father Christmas. The court will not give what you did not ask for. So it will take someone going back to court and say, okay, it's been discovered that the person who served these 4 years should have not served. Every money, every allowance, every salary, everything that he earned during that period should be taken away, should be taken from him. So that's the only retrospective effect that that can occur in this circumstance, not the tenure in office.
All right, let's talk in terms of the developments that is currently greeting the entire world in terms of technological and development around the world. How developed has the Nigerian judiciary become so far, even in terms of assessing it under President Bola Ahmed Tinubu? In terms of its technological advancement, have we gone past where we were 26 years ago? Have we improved, or where are we right now?
Okay, well, one thing I've been trying to do since this discussion is to avoid linking the president with the judiciary, I would want to say these two bodies remain independent. Now, however, technologically, how much or how well have the judiciary gone? Now, to a large extent, it's not something that would happen overnight, but I can say gradually we're achieving something. We have so many of our courts now that have become automated. That is, you go to court, the judge is not writing. And the reason he's not writing is because there is a machine in the court that picks your voice and transcribes it. As you are speaking, it transcribes. There's a court we go where the judge will tell you before the matter starts. He'll say, if you have a name that is not an English name, please spell it, because the machine cannot pick a name that is not an English name, or it will misspell it. So if your name is not an English name, you have to spell it, So we have a good number of our courts that have become automated. You don't see judges writing again, especially the federal high courts. Many of the chambers, you don't see the judges writing again. They just sit and everything is being transcribed. In fact, if you want the CTC of the proceedings for every day, you can get it. So to an extent, we have improved from where we were 20 years ago. Now, we're also getting to a point where the issue of access to judgments of the higher courts, or even judgments of the federal high court or state high court, it's now becoming more accessible. For example, now, I'm writing a brief presently. I don't have to go to any library now to begin to search through hard copy books, hard copy law reports, to begin to do all that. These are things you can now access on your phone, not even laptop. You can just pick your phone, enter into any of these law reporting apps, look for what you need. So we've moved. Before, in those days, it used to be a pride for a lawyer to go to court with 3 bags of books loaded. You are going, you are more or less harassing the judge.
Colleague.
Yes, harassing the judge.
You're a learned fellow.
You go to a court sometimes, you will see books like this in front of a judge, in front of a lawyer. Is coming to intimidate. All that has changed today. In fact, it has changed to the point that even your diary, you can open your phone and access your diary on your phone. So we have moved far from where we used to be. Many of these things have been integrated in the practice of law, both at the judiciary, both at the bench and at the bar. A lot of technological improvements have come in. It's not what it used to be.
Barrister Balogun, the doctrine of separation of power, like you've said, of course, it's supposed to be that the principle of separation of power is that the judiciary is on its own, the executive is on its own, while the legislature is on its own. But in Nigeria, when you look at the principle of separation of power, have we really gotten it right? Is the judiciary actually independent away from the executive? Is the legislature actually independent of the executive, knowing fully well that the appointments even for judicial officers come from the executive arm of government, and the confirmation also come from that of the judiciary and from the legislature? Somebody will say that he that plays the piper dictates the tune. Even in the principle of separation of power, has it been effectively harnessed in Nigeria so far?
Okay. Actually, just on a personal view now, there are some things that I have, or that I would say, that I feel they're not too appropriate. Now, on this issue of separation of power, the truth is this: the entire funds, the entire income, the entire resources of Nigeria lies in the hands of the executive. So it's still the executive that will push to the legislators and say, this is for you. It's the same executive that will push to the judiciary and say, this is for you. It's the same executive that push to the state government, this is for you. Federal government to push to the local government and say, this is for you. So to a large extent, a lot revolves around the executive. You cannot take that away from them. Now, one of the things I actually had an issue with is the fact that when a CJN is to come into office, the CJN is being sworn in by the president. I honestly, I'm not comfortable with it. Because this is where issue of independence comes in. I wish there is another way around it. Of course, the president is also sworn in by the Chief Justice of the Federation. Fine. But you see, I seem not to be comfortable with the fact that it is the president that swears in the CJN. But the question now is this: who else would have the authority to do that? Who else is there, up there, in terms of ranking, that will be able to do that? There's no other person but the president. So that is why it has to remain like that. But then, you see, as much as possible, this issue of separation of power, it just has to be. The fact remains that all funds is controlled by the executive. So, yes, as much as we are saying, yes, there should be independence of the judiciary, there should be separation of power, see, it is not totally achievable as long as the funds is still coming from the executive. It is not 100% achievable. We have had times, for example, now we are talking about local government autonomy and all that. There was a year during President Obasanjo's time where the funds for local government for Lagos State, they seized it for several months. Now, if we had this total independence or autonomy, something like that cannot happen. But the fact is this: the money is coming into the hands of the executive. Look at what is happening in Osun State now. Presently, the funds for the local government of Osun State have been seized. I don't know if you are aware.
Yeah.
It's been on the news. I think the governor of Osun State, Governor Adeleke, was with the president, I think 2 or 3 days ago, and these issues were being discussed. It is because the executive is at the center. They are the ones holding the knife. They are the ones holding everything. It is what they say that is practically the law. But then we are still saying there should be the independence of the judiciary. There should still be that separation of power as much as possible. It is not 100% achievable, but to an extent, we can push it.
Barrister Kintayo, just before I let you go, just recently, yesterday to be precise, we saw the Nigerian judicial officers, the Nigerian Union of Judicial Workers, called off their strike in order to return back to office and open some of the courts that were under lock and keys. I want to find out, as a lawyer, even in this regard, are judicial officers supposed to go on strike and in any form?
Okay, the truth is, you won't blame them. You won't blame them for going on strike. And I also would not blame them, especially when the federal government has said, we will do something, and then you don't do it. Now, you know that in 2023, the price of fuel jumped by over 100%, over 200% in 2023. And since then, there have been consistent rise. Though of late we've been having, the prices have been coming down. Remember, price was less than 200 naira. It jumped to over 500, 600, 700, 800, 900, 1,100. But then we have been having gradual, it's been coming down. At least Dangote fuel sells for about 850 naira on the average. Now, the minimum wage was 30,000. If you remove 30,000 in the present situation, in fact, as it is now, 30,000 cannot, the vehicle I'm using now, 30,000 cannot bring the fuel to half. 30,000 cannot bring it to half. So if I buy 30,000 naira fuel now, someone will say I just bought minimum wage now. How would you expect that workers should continue? Remember, the judiciary is a very sensitive place in the sense that other civil servants, if you remember, there were some states that announced that let's do a roster. You can come Monday, Wednesday, Friday, Monday,
3 times
Tuesday,
in a week, yeah.
Like that. That cannot happen in the judiciary because especially the judicial staff, the ones that work in the court, you cannot choose the day that you will come because the court sits Monday to Friday. So if the court sits 5 days in a week, you have to be in court 5 days in a week. and then you are still paying them 30,000 naira. How do you expect them to cope? So we have to look at these things. You won't say, I won't begin to borrow money to come to work. I'm earning salary, and practically everything that I'm earning is going into purchase of fuel or into transportation. The vehicles that we used to enter for 200 naira from, let's say, somewhere like Kubwa or somewhere like Maraba, now goes for 700 naira. That is over 200% increment. Now, by the time someone is entering 1,500 naira in a day, in 10 days, that's 15,000 naira. In 20 days, that's 30,000. In 30 days, that's 45,000. And you are collecting 30,000. How do you expect that person to cope? So now, let's say 45,000 goes. You decide to even pay that 70,000. How much is remaining? That's 25,000 naira remaining. Is it that amount? Is it on that amount you expect someone to live?
And you need to feed.
And you need to feed.
Pay rent.
You need to pay rent. You know what rent is saying in Abuja. you understand? So for me, I wouldn't blame them for going.
And you still need to sit out with the boys.
Exactly. You need to relax. Life is not about work. Life is not all about work.
Yeah.
So honestly, I won't blame them. There needs to be a full implementation of that. We know 70,000 would not do much, but at least if this is what you have promised, then do it.
In overall assessment of looking at the judiciary, of course, you have said you don't want to link up the presidency with the judiciary, which we would totally agree with you on that. But then let's look at it in a scale of 1 to 10, assessing the relationship that has existed between the judiciary and the executive. In a scale of 1 to 10, where will you place this relationship so far between the executive and the judiciary?
Okay, I would say that so far they have complemented each other to a large extent. We have seen the Supreme Court do its bit, or let me not just use the word Supreme Court. We have seen the judiciary do its bid. We have also seen the executive also do their bid. So let's say the relationship to a large extent have been symbiotic. Everybody playing his own part, at least from what we can see. You know, there are so many decisions, of course, even of the Supreme Court, that have been heavily criticized within the period. And we have seen strong criticism. We have seen decisions that seem not to go well, you know. But then, like we said, the Supreme Court is supreme. Whatever they say is the law. Even if they say something today and they say something else tomorrow, what they have said tomorrow is the law until that changes again. So I would say the relationship to a large extent have been cordial. It's been symbiotic. They've been working hand in hand.
And as such, if you want to put it in a figurative term, what would that now be?
I'll give it 8.
It is in that case. Well, I want to say thank you so much, Barrister Akintayo Balogun, for finding out time to be with us here on Big Talk.
Thank you very much, and thank you so much for having me in the studio.
Well, viewers, this is how far we can go this evening on a Big Talk. Do remember that you can join the conversation on our various social media handle right now, showing on your screen using @Global TV NG. My name is Godwin Sunday. Always remember that peace and unity are the pathways to progress. Till Big Talk comes your way again. Enjoy the rest of your evening.